Adjournment request, if any, from item number 1 to 8.
May I please, Your Lordship? With consent of respondent, I beg to mention item number 7 and 8, Lordship. Matter kindly adjourn for 2 weeks, Lordship. Adjourn.
Please, Your Lordship, with the consent of the other side, I beg to mention item number 6 of the daily list.
Adjourn.
Obliged.
Item number 2, Lordship. I need a little accommodation to the Lordship.
Taken that?
Item number 2, Lordship.
Yeah.
I need some accommodation, Lordship.
That's the number come.
May I please, Your Lordship? Lordship, I beg to mention item 3, Your Lordship. Lordship, the matters become infrastructure, Lordship, after the introduction.
Yes.
Yes, Your Lordship.
I am for a respondent.
Dismissed as in pictures. So all other petitions listed along with there also in pictures?
All in person.
On last week, we have made a mention, Your Lordship.
In those petitions. Dismissed as in pictures.
Adjournment request from item number 9 to 14. Any other request?
Would my not be pleased to allow listing of a writ appeal tomorrow?
Tomorrow, what's the urgency?
The board has been dissolved. By the, what had happened is that the board was, election was held. Thereafter, it was approved.
Single judge has dismissed.
Absolutely.
Monday.
Obliged, Lordship.
Daily list for orders item 1.
Lordship, please.
Yes, who is for the state? My lord, I have received some instruction, my lord, I have gone through it. My lord, this instruction is not sufficient. May I pray for some more time, my lord, to get the. That is your headache, sir, not of this board. Not required to have the. My lord, why this whole land, this 15-year cap was why this was removed? My lord, that instruction, my lord, I have gone through it, my lord. That particular instruction has not been forwarded to me, my lord. That is why, my lord, I sought for some time. Wednesday. Well, next week, any day, my lord. Wednesday. Next Wednesday. Next Wednesday.
The service of, I think, respond number 10, 12, and 15 has come back in regards to the office report has come back not.
Yes.
So I think that will also have to be served.
Not being served. Yes.
But I appear for 9, 10 and 11.
Sorry, your Lordship, that AD has not come back, 10, 12, and 15. What is it?
9, 10 and 11, you are appearing. Who is appearing for 12, 13, 14? And who is appearing for 15?
It's not come back. AD card has not come back, 10, 12, and 15.
I am appearing for my lord 5, 6, 7 and 8.
I would also like to smile and thought affected on the maintainability part of it.
Let's find your reply. This number 1, 2 and 3. Yes, you are appearing for 1, 2, 3, 4.
Okay.
And who is appearing for 5? District Commissioner.
I am appearing, my lord. I am appearing for 5, 6, 7 and 8.
7 and 8.
My lord.
What about 9?
9 I am appearing, Lord. 9, 10 and 11.
9, 10 and 11.
Yes, sir.
Yes, sir. 9, 10 and 11, you are appearing 12. You are appearing for 12. 13, 14, 15. 13 and 14 and this registrar of firm societies, some you are appearing for.
The state authority.
15.
Obviously,
Yes, my lord, I can appear.
So then it's complete.
I'm the presence of the market there. Service is therefore complete. So and so is appearing on behalf of all the respondents. Service is therefore complete. The respective respondents, a concept for the respective respondents place some more time to file. Counter to their writ petition, time paid for is granted. List this petition on Wednesday.
But may I say, Your Lordship, Friday, Wednesday, I have a slight difficulty. I'm not available.
Friday,
I'll be extremely grateful.
next Friday. 56. Okay.
Item number 2.
Thank you.
In this case, my lord, my learned pen appeared for the fishery department. I am appearing for the district commissioner, my lord. Response number 3, 4, and 5.
My lord, some time is required for taking the instruction.
Okay. Mr. So put in appearance on behalf of, or you are appearing for? I am appearing for my lord, response number 3, 4, and 5.
And for 1 and 2.
1 and 2. Only 5 respondents are there? How many?
Only 5 respondents are here.
5. 3, 4, and 5. ये लिखिए, इनको appearing on behalf of the respondent number so and so. Please some time to file response to the DPP. Time period for is granted list after 2 weeks. Interim order passed by this court on 14/6/2024 shall remain in currency till next date.
Pleasure.
For hearing item 4 and 5. Item 5, my lord, But here, my lord, we have challenged government notification reducing the grade pay, my
You
lord.
are appearing in item number
My lord, 5.
5.
Yes, my lord. 2763. In this
Yes.
case, we have challenged the government notification, my lord. Earlier, ROP, my lord, Assam Service Revision of Pay Rules 2017. My lord, it was the decision of the government, my lord, of Assam, my lord. They have assembled and one meeting was held, pay commission meeting was held. They have decided to pay all the graduate teachers same grade pay, my lord, 8,700. Subsequently, my lord, they have, my lord, it is, my lord, it is reduced, my lord, by the anomaly committee. But anomaly committee is, my lord, constituted only for the employees, my lord. But government decision is that, my lord, they have, when they have gone there, my lord, subsequently government decided that it is reduced, my lord. The government notification is, my lord, as paid, kindly peruse your lordship. That is Annexar 2, my lord. Page 24 in my repetition, my lord.
One page scholar. 20.
24. And page 23 also, your lordship peruse.
Just a minute. Ask. Yes.
After 2010, 2017, this Assam Services Revision of Pay Rules 2017 it was. And it was the decision of the government, my lord, to pay the same grade pay, 8,700, my lord. Government has, my learned friend has filed affidavit on, my lord, 23/10/19. Kindly peruse your lordship. Page, my lord, that is 39, my lord. What was the decision of the Assam 7th Pay Productivity Pay Commission, my lord? Relevant portion, page 40. S40. S40C. The commission feels that at the level of LP and ME school, there is no justification for differentiating the qualification of science graduate vis-a-vis arts graduate or any other graduate. According to the commission recommends that all the graduate teachers in LP and ME schools should have the same grade pay of 3,300. If it is further recommended that all the other teachers who have undergraduate qualification should be put in grade pay of 2,500. Before this, my lord, ROP rule, my lord, 2017, they have decided. And accordingly, my lord, they have given us the same grade pay, my lord. In ROP rule,
Yes,
8,700 for all the teachers.
Seventeen.
Me, MB, senior basic school, grade headmaster, 8,700. In ME, MB, senior basic school, graduate teacher, 8,700, my lord. And next page, my lord. LP junior basic pre-primary school, head teacher, 8,700, graduate teacher, 8,700, my lord.
Please, actually second. It's 2018, no? Yes. Okay. Yeah, this is below. Let's see. Out for this. There is the recommendation of the anomaly committee.
My lord, that is, I have annexed here, page, in the epidemic, page 24, my lord.
Page 24, annexure second.
Yes, second. Relevant portion, my lord, page 25
Just a
at clause 9.
clause 9.
9, my lord. They have separated, divided in this way.
LP Junior Basic
Yes,
School, pre-primary school.
yes, my lord.
So you are the
Trained
petitioners
graduate
are the
teacher.
pre-primary school teachers.
Yes, my lord. Primary school teacher, my lord, LP school teacher, trained graduate teacher, my lord.
LP, what do you mean by LP?
Lower primary.
Lower primary.
Yes, my lord.
And this ME means
Middle, my lord.
Middle English grammar. Class 1 to 5, lower primary.
lower primary,
Then upper
junior
primary,
basic school and pre-primary school.
Yes,
are
they
the
are on
same.
one category, one
Same.
category.
And the another is ME,
Upper primary and MEM.
ME, MB or senior basic school,
They
Yes,
all
my lord.
fall in the same category. They are the upper primary from class 6 to 8.
8.
class 6 to 8.
8. 9 and 10 come in the high school.
So earlier, this pay grade of all these LP junior basic school, pre-primary school teachers and upper primary schools teachers
Same.
were same.
Same.
In the, this ROP 2017.
17. Page 23.
He'll explain the finance part.
Yes.
My lord, so far as the, my lord, ROP 2017 is concerned, my lord, initially, yes, it was safe. It was 8,700 for all, my lord, graduate teachers.
Yeah.
Here, my lord, the issue is the writ petitioners herein, they are assistant teachers of LP school. And my lord, they are graduate.
They are great.
On qualification, they are graduate. But the post, my lord, the post of the assistant teacher LP school, there the minimum qualification for holding that particular post is only intermediate, that is class 12 pass. So our, my lord, stand is this, just because they are graduate, they may be a postgraduate also. The pay
Post
scale will,
which they are holding,
yes, it is intermediate, my lord. That is, my lord, class 12 pass. So even if they are, my lord, graduate, they will be given the pay scale commensurate to that particular post. ROP is always against the post, not considering his qualification. Tomorrow he may have the doctorate degree too, but that doesn't mean that he will, my lord, claim for a pay scale of a college teacher. So that's our, my lord, entire basis. But when this, my lord, anomaly came to our knowledge, my lord, the government placed the entire issue before the anomaly committee. Now, anomaly committee thereafter, instead of 8,700, has reduced it to, my lord, 7,400, page 25. So they want that, my lord, it should be similar to the graduate teachers of ME school,
upper
And-
primary school.
upper primary school. That is, my lord, the entire dispute, my lord.
But upper primary school also elementary school under elementary education, my lord, intermediate post.
It's another,
Mm.
whether you are the teachers in the pre-primary school,
Yes, my lord.
though you are having the qualification.
Yes.
What is the requisite qualification for appointment of a teacher in the
My lord,
intermediate?
undergraduate, Now it is
Intermediate or higher
graduate.
secondary, whatever it may be.
higher secondary, my lord,
Higher
yes.
secondary.
Higher secondary. And for the purpose of this appointment in the upper primary school, a
Same.
teacher is required to be, have the qualification of graduation or?
No, earlier not, my lord. They have subsequently this separation has brought, my lord, without amendment.
Sufficient. What is the minimum qualification for?
Same qualification.
Same qualification.
Yes.
My lord, there are, my lord, intermediate post, as well as,
Intermediate.
my lord, science graduate post. So, my lord, on that issue also regarding ME school teachers who are holding the intermediate post, my lord, they are also claiming, my lord, 8,700. That writ petition is also pending before the honorable court.
And
Before the division.
they were also, they were granted pay.
No, my lord, we have not granted them.
No, you have granted them pay scale.
Yes, I have annexed.
Uh,
Yes.
my lord, it-
7,400,
No, 6,800.
6,800.
Yes, my lord. Only, my lord, science graduate teachers, where, my lord, there is a specific post.
Science, arts and commerce.
No, there is a specific post that is science graduate teacher in ME school,
Yeah,
where, my lord, the minimum qualification is, my lord, graduate. There, my lord, we are granting, my lord, 8,700. And the teachers, my lord, in ME school who are holding the intermediate post, they have been granted 6,700. So being aggrieved, they are also before this honorable court challenging this particular, my lord, amendment of the anomaly committee.
this is the second petition.
No, my lord, there's a separate case, my lord, of ME school teachers. This is the LP school teachers. These two cases relates to LP school teachers.
Which is that petition?
Yes, yes. We know it. I can give the number.
Kindly peruse your lordship, my affidavit, my additional affidavit 8/11/23. I have annexed here pay slip, my lord. It is not correct, my lord.
Pay slip of whom?
Both school, my lord, upper primary school teacher, my lord. Arts teacher is also getting 8,700. Page 86, my lord, kindly peruse your lordship. Annexure 5.
So whatever it may be, even though if they have granted them and granted them erroneously.
The negative
we
equality
will
will not
write
come
in
in.
your favor, sir.
Kindly peruse your lordship 86 page.
86.
Yes, my lord.
Yes.
8,700 science teacher.
Science teacher.
Yes.
graduate.
Next page, my lord.
Yes.
Assistant teacher ME school 8,700.
Placement of month, July.
After the anomaly committee's decision also.
What
This
is the
July
qualification?
2023 pay slip.
His qualification is?
Same, my lord, graduate teacher. And next page also kindly peruse your lordship. Page 88, 7,400 because he is LP school teacher. LP is in same school, my lord. If one graduate teacher is getting my 8,700 and another teacher is getting, my lord, 7,400 grade pay.
So far as regarding this page 86 is concerned, that is senior ME, senior teacher ME.
Yes,
so
yes, your
that
lordship is
you
correct.
Can't, now, what about this, page 87?
87 also, my lord.
ME.
ME
not
school,
LP
madam.
school, madam.
ME?
ME school.
ME school belongs to the upper primary school, my lord.
Oh.
Same, my lord, graduate teacher. In the month of July 2023, payslip.
How is getting this assistant teacher to ME?
Yes.
Also getting the same pay scale?
My lord, on that point, it's not that all is getting, somewhere, my lord, in the district level, some has been granted there. But that part, my lord, the government is looking into that issue. In fact, my lord, there are some series of meetings have been held where, my lord, we both were also present in the government, my lord, in the other case, my lord. In fact, there is a judicial order to the honorable court that this should be sorted out in the other case of ME school. Because, my lord, they are claiming that some are getting, my lord, some have not been granted. Where our consistent stand is that, my lord, only intermediate teacher, even in the ME school, will get the 6,800 only, not 8,700.
8,700. Appendix here.
That case number, my lord, I can otherwise provide.
তুমি তো কি লিখেছ আপনি লিখে আসলে আপনি লিখে পড়বেন কি করবেন আচ্ছা দেখুন কি দেখি আরো তেরো গোটা কি লিখা পড়বে
Yes.
My lord, if Lordship has the manual, my lord, for a moment, we can explain the entire issue.
Which one?
Yes, the, no, but the
Education
education
manual.
manual.
Even Hindi teacher are also getting 8,700. Hindi graduate teacher in the ME school.
Who are getting?
8,700. It is not reduced.
Which persons are getting this?
Hindi teacher of the upper primary school.
That's another thing.
Lordship should have page,
He is in upper primary school, that's another.
Yes, my lord.
Lordship should have page 18,
Post this interview.
18, my lord. That is the Assam Secondary Education Provincial Service Rules. And Lordship should have page 21 thereafter. Page 21.
Yes,
This is part of section 2 definition, clause I,
yeah,
graduate teacher.
yes.
Means and includes the category of assistant teacher, classical teacher of higher secondary, or senior secondary, as well as junior or high madrasa or high school, including amalgamated higher secondary, senior secondary, or high schools for whose appointment, Lordship will find minimum qualification is graduate in arts, science, commerce from a recognized university, including demonstrators of a provincialized higher secondary school. Then Lordship should have M. A junior teacher means an undergraduate teacher of the higher secondary or a high school, including amalgamated higher secondary or high schools. So these are two different categories of the junior teacher is now defined at, if Lordship will kindly come to page 365. This is part of the Assam Secondary Education Provincial and Service Rules 2003. Page 365.
Yes,
N is again a graduate teacher definition given in the earlier act. And O is junior teacher means undergraduate intermediate teachers. Now, Lordship should kindly have my affidavit file in WPC 2763 of 2019.
you are on behalf of respondent number 2.
My lord, I am for the education department.
Education department.
I'll just show the classification of the teachers and finance will show how the pay scales are to be. My affidavit in WPC 2763 of 19 starts at page 66 running,
Yes,
and at, if lordship would have, page 67 para 3.
yeah,
It is stated that the service conditions of employees serving in provincialized elementary schools are governed by the Assam Elementary Education Provincialization Rules 1977. The rules classify the elementary schools into two categories, namely lower primary schools where education is imparted up to class 5 and upper primary school where education is imparted up to class 8, including middle English, middle vernacular, middle English madrasa, and senior basic schools. 4. That it is stated that the following table would provide the assistance to trace the history of provisions of law which govern the requisite qualifications for recruitment of teachers in elementary school. In 1997, for lower primary, it was only matriculation. Upper primary also, it was matriculation. In the year 1981, it was brought up to matriculation or high school leaving certificate remains the same. 1997, it was matriculation, high school leaving certificate, or for upper primary, it was higher secondary or the equivalent. 2001, we changed it into senior secondary with diploma. And 2005, it became senior secondary for lower primary, and for upper primary, lordship will find assistant teacher, senior secondary for science graduate teacher. Now, there was a scheme where we introduced certain class of teachers to teach maths and science in upper primary schools. Those teachers were only required to have graduation degree, and they were called science graduate teachers. Thereafter, in 2010, my lord, the NCT took over. And NCT laid down the norms as senior secondary with diploma for lower primary, and for upper primary, it was senior secondary or graduation. But the lowest qualification even for upper primary remains senior secondary. In 2012, there was an amendment which again remained same for lower primary, that was senior secondary with diploma in elementary education. So one of the persons who are now serving in the elementary education department in lower primary schools have a basic qualification of only senior secondary, and now it is either with TET and diploma in elementary education. Now, if lordships would kindly have a judgment which I had given. There was 2009 5 GLR 230. This deals squarely with this issue of division bench judgment of this honorable court. There, my lord, in the Assam Rifles, the teachers who had graduation were asking for graduate scale of pay. Lordships will kindly have the para 3. Petitioner having been selected for appointment as junior teacher under the establishment of Assam Rifles, she joined the post on so-and-so. Existing pay scale of junior teacher at the relevant time was so-and-so per month plus allowances and as per rules. The petitioner raised grievance that she being graduated with B.Ed, she is entitled to get the pay scale of rupees so-and-so per month from the date of her joining, and with effect from so-and-so, her pay should have been fixed at so-and-so others. Now, lordship would have para 7. Taking note of the submissions made by Dr. Singh, now the point that falls for consideration before us is whether the petitioner is entitled to be paid the pay scale of trained graduate teacher. Admittedly, the petitioner was not appointed as trained graduate teacher. The petitioner might have had the qualification of graduation with B.Ed degree, but unless she is appointed to the related post of a trained graduate teacher merely by having higher qualifications, she is not entitled to get the benefit of higher pay scale prescribed for such higher post. It is further notice that the required qualification for junior teacher is intermediate or 10+2 standard and not graduate. The petitioner was appointed to the substantive post of a junior teacher. It is the case of the respondents that the categories of post as trained graduate teacher is not available in the establishment. The petitioner having been appointed to the substantive post in the cadre of junior teacher and the post of junior teacher, the trained graduate teacher being different cadre and category, in our considered opinion, the claim of the petitioner is misplaced and she is not entitled to claim the pay scale of a trained graduate teacher. In view of the above discussion, we do not find any merit in this writ petition accordingly dismissed. This was a matter which came from the CAT. Division bench of this honorable court.
yes,
Unless they were appointed to a certain post, they cannot claim this salary for that particular post, is the case of the department also. And that Hindi graduate teacher or science graduate teacher, those are different classes which lordships should find even in the earlier rules where they were taken in with graduation only. That lordships should find at the same The same book, page 389. Page 389, if Lordship has for a moment of the book.
Yes.
Page 389, my lord, it says this rule, my lord. Not the
Page.
my lord, this book, the book again, my lord, this book. The rules, how they defined it. In the year 2003, it was defined. Page 389, down below the footnote part, Lordship will find number 2.
Yes.
The minimum qualification for graduate teacher as well as language teacher should be graduate in arts, science, and commerce. So there were certain class of Hindi teachers or science teachers who were brought in into the service as graduate teachers in upper primary schools or for upper primary classes in elementary schools. So teachers who are restricted to LP schools, LP classes, lower primary classes, they come in only with the only requirement is the senior secondary or higher secondary, as we call it. And if that is so, my lord, then the graduate scale of pay would not be applicable to them. And for those, my lord, in the other cases where for upper primary, they are claiming as graduate teachers and some discrepancies there, what had happened is there was one judgment of this honorable court which said that graduate teachers either of upper primary or of high schools would have the same status, and therefore they should be considered for headmasters or principals. Now that same status was only for the science teachers. Department in some of the districts misread it that all graduate teachers of upper primary schools would be entitled to that salary. Therefore, anybody who was a graduate was given in some of the districts. That is being re-looked into by the department. Bless you.
My lord, I am placing,
I have placed the report of the anomaly committee, the relevant part. Lordship will find at page 9 of that bunch. There was several representation from the, my lord, LP school teachers claiming 8,700. It was duly looked into. Lordship will see, my lord, page 9.
9.
Details of demands and corresponding views of the anomaly committee. Now, Lordship will turn to, my lord, page 11. Page 11. It starts, my lord, the name of the department, education department. Page 11.
Yes.
Here, my lord, at the bottom, Assam State Primary Teachers Association, the 7 APPC has recommended a post of headmaster in so and so. There also they claim, my lord, 8,700. No recommendation was given. Same way, my lord, in page 12, same at the bottom, all Assam middle graduate assistant teachers, Kalyan Santha, serial number 16. They also claim, my lord, 8,700. Same LP
All
school.
Assam?
All Assam middle graduate assistant teachers, Kalyan
number?
Santha. Page 12.
12, my lord.
At the
but
top,
they are
my lord,
not graduate, trained graduate teacher, my lord. Trained graduate teachers are in, yes, my lord.
Yes, understand. Appa will provide you the opportunity. They are not going to
Yes, yes.
stop you.
page 12, my lord. Thus I'm placing, my lord, some demands were there from their side. Same way, my lord, page 13.
Just a minute. Page 12. This, all Assam middle, yeah.
Yes. Serial number 16, my lord, at the top of that column.
Yes.
And enhanced grade pay of 8,700. This is the, my lord, demand they made. Same way, page 13. Serial number 26. All Assam Prathamik Teachers Association. Serial number 31. Trained and untrained teachers of LP school should be given grade pay of 8,700. This was their demand
Yes.
by different association.
Yes.
And my lord, again at my lord, page 15. At the bottom, my lord, serial number 66. The association is BT B.Ed Postgraduate Assistant Teachers Association. 66, my lord.
Yes.
there should be difference in the case of pay scale between graduate teacher of high and higher secondary school levels and assistant teacher of LP and upper primary schools having graduate qualification. Some demand was made that there should be some difference regarding the grade pay.
Yes.
So, my lord, considering everything, finally, my lord, finally the view was given by the anomaly committee that lordship will find at page 23 of that bunch.
Yes.
Lordship will see page 23. This has already been placed by my colleague, my lord, in page 24 of the repetition, which finally culminated into the, my lord, notification which is under challenge in the present repetition. That is 4th of August 2018. The ROP 2017 has been amended. Now, my lord, they have been given the grade pay of 7,400, 6,800 and 6,200 instead of 8,700 and other.
Here the set of teachers are these yeah, trained graduate teachers in the LP and untrained teachers are also here.
Yes, yes, it's there in the chart. It's there in the chart.
All things are combined now. So this petitioners are trained graduate teachers,
Yes, madam.
untrained graduate teachers, including
Not
trained
untrained.
undergraduate teacher.
We are not untrained.
Great.
We are
We are
not
trained graduate teacher only.
trained graduate teacher.
Yes, madam.
Otherwise, yes. The post, my lord, which they are holding, considering that they will come under the trained undergraduate teacher because the post is the intermediate post. If we go strictly by our stand, my lord, even my lord, they will not be entitled for my lord
So
7,000.
here the set of petitioners are trained graduate teachers and trained undergraduate teachers
Trained undergraduate teacher, considering the post, my lord, intermediate post.
working in the LP schools.
LP schools, only LP schools.
We are trained graduate teacher only, my lord. And similarly, my lord, upper primary school also, there are trained graduate teachers. Their post has not been changed. It is graduate. It is recognized as graduate.
Simply because the nomenclature is same,
Yes, my lord.
you can't claim this as a matter of right.
Already it was given, my lord, in the
It was
mark.
given, but
Yes.
ultimately if an MOU was.
But
found and it
notification
a
was, my lord,
policy
published.
decision Of the state government.
Set aside by the this honorable court,
It's a
my lord.
Policy decision of the state government.
Yes, it is correct, but my lord, they are lower classes, my lord, employee, my lord.
It is judgment of the Supreme Court.
I have already given that, my lord. Would it not, my lord, causing any alternation health?
Judgment.
But I have placed there, my lord. Alternation health
Day
cannot be,
Before yesterday judgment.
oh no, my lord, that is, I have not received. But these are the judgment, my lord, one of 1975. A confirmation health entails workmen.
Day before 15th of July judgment.
18th of July.
Okay, there.
The,
Para 53.
This gives.
Graduate word does not describe the person concerned. The graduate word is for the post here. The trained graduate teacher will not the teacher who did not graduation and as well as training. Otherwise, the word would have been exposed to the teacher also.
One judgment, my lord, I would also like to place regarding equal pay for equal work. It says, my lord, that it should be complete and wholesale identity. Wholesale equality will have to be there, not only the qualification, my lord. Mode of recruitment, nature of duties, my lord.
yes, my lord. Qualification here is the same, my lord, 10 graduate teacher. But what is happened, my lord, I have given, placed some judgment, my lord.
Yes, 53. para number, read the. para
Yes,
number.
my lord. It needs no emphasis that a prescription of pay scale for a post entails policy decision based upon the recommendations of an expert body like pay commission. All that the state is obligated to ensure is that the pay structure of promotional or higher post is not lower than the feeder cadre. Similarly, pay parity cannot be claimed as an indefeasible, enforceable right, save and except where the competent authority has taken a conscious decision to equate two posts notwithstanding their different nomenclature or distinct qualification. Incidentally, grant of same pay scale to two or more posts without any express equation among such posts cannot be termed as anomaly in a pay scale of nature, which can be said to have infringed the right of equality under this Article 16 of our Constitution.
So here, where the competent or conscious decision to equate two posts, notwithstanding their nomenclature and distinct qualifications. What is that? There is no decision of the state government to treat these two posts equivalent of upper primary school or.
Lower primary.
There is no such decision.
Both are intermediate posts, my lord. Even upper primary or lower primary, both. But
These posts were not equated by the state government at any point of time.
but equated in the sense, my lord, to provide the same grade pay, my lord. Graduate teachers.
It seems to be reasonable that since the persons who are working in the LP school, lower primary school, and the persons that are working in the upper primary schools, employer teachers, there is a separate class.
Separate class, but whatever may be, my lord, both are
Simply
intermediate.
because
And
you are graduate,
yes, my graduate.
can't claim that I am entitled for that pay scale of graduate.
Well, it
teacher.
is absolutely discrimination. Kindly peruse your lordship.
Discrimination.
Just
is
I'm
what
please-
the Supreme Court has said.
Hmm.
Cannot be said to be infringed right of equality under Article 16 of the Constitution of India.
Yes, my lord. If one teacher, my lord, if the school is merged with the, my lord, high school, my lord, one LP school teacher will be able to get as a graduate, whatever may be, 7,400. And another,
That they have
yes,
clarified that is there is.
yes,
animosity.
these arts teacher are
But-
getting,
Yeah, you have pointed out that.
yes, my lord.
Yes,
That
that's
aspect
right.
is there, my lord.
If some persons are.
Graduate teachers are,
getting this,
yes,
Whatever the. pay-
8,700
If they are getting erroneously,
erroneously.
that will not create any
But-
right in favor
But
of you.
they have, but not, they are not getting erroneously because it was the decision of the,
They have said that.
and now they have,
This is what
here-
the erroneous decision and the deliberations are going on. That-
and my lord, I have placed some judgment, my lord.
Yeah.
Yes, my lord.
Which judgment you are relying on?
First judgment, my lord, of the pay scale cannot confirmation held entitles workmen to right to post.
Which judgment you are?
My lord, it was, my lord, 1975,
1975.
3 SCC 1. I have placed the copies, my lord.
Yes.
That is, my
Divisional
lord,
Superintendent Eastern Railway.
yes, my lord.
Yeah.
Here, my lord, the respondent were confirmed in the scale of rupees so and so appellants having fixed the scale and confirmed the respondents could not reduce the scale without giving any opportunity to the respondents to be heard. Furthermore, the respondents on confirmation became entitled to rights to the post to the scale of pay fixed by the board. And number two is, my lord,
Opportunity of hearing. Individual is not given, but the NOLA committee has considered the representation of various organizations and thereafter they have decided.
decided, my lord. And next, my lord, judgment, my lord. Last, I want to place, my lord, judgment, my lord, that is 2003 10 SCC 297.
2000,
Last, my lord, serial number 4 judgment.
yes, 297.
Yes, my lord.
Yeah.
Here, my lord, condition of service alternation of health cannot be altered to the disadvantage of the employees by reducing their pay scales or withdrawing any service benefit, but there is no bar to offer such employees better prospects. The same work is there providing, my lord. Putting this disadvantaged position, it cannot be reduced, my lord. These are the low class, my lord, employee, my lord. They are getting some,
Low class employee, what do you
my
mean?
lord,
low
because,
class?
my lord, they are getting very minimum salary, my lord.
Total salary is, I think so, more than 50,000.
Yes, more than 50,000.
That 50,000 is not.
And the
a-
difference is
it's
also,
Not a.
and also
Paid by 6,000-7,000.
pay in parity also come, my lord, because same teachers are getting, my lord, graduate teachers are getting, graduate teachers getting 8,000. That is the- I have
Differentiate between you and the other persons because they were working in the upper primary school where the qualification is graduation.
graduation, my lord.
Here, your qualification for appointment as a assistant teacher or junior teacher in the LP school is secondary, higher secondary.
I said, but they also same.
But they are getting this, but since you are graduate, you are claiming that we should also be granted this benefit.
But because my lord, kindly peruse your lordship, upper primary also, their teachers are all from the intermediate post, but they are getting the same benefit, my lord. But we have given accordingly, my lord, pay commission, my lord, decided, my lord, and it was considered, my lord, that both the science teacher, graduate teacher, arts teacher, all will be able to get 8,700. That was the decision, my lord. Subsequently, this anomaly committee deviated and it is, my lord, divided into two parts, my lord. That is the only, my lord, my prayer, my lord, because, my lord, they cannot, my lord. Because they have
By
to,
amending the rule.
yes, rule they have to can amend.
They have amended that rule.
Not, my lord, this Elementary Education Act was in the earlier, my lord, it was
309, this notification is under section
69 Act.
309.
Assam Elementary Education Act 1968, my lord.
ROP rule, they have amended.
ROP rule, yes, my ROP rule, they anomaly committee, my lord, cannot, my lord, divide in this way, my lord. Because they specifically, they have, my lord, already incorporated in the books, my lord. And also given us their benefit also, my lord. And pay parity, my lord, I have, for pay parity, because same service has been rendering by the school teachers, I have placed two judgment also, pays, my lord, para 28 and para 16, my lord. I have given there, my lord.
Which judgment?
Judge, my lord, that judgment is 2010 5 SCC 225.
Yes.
That is equal pay paragraph 28. Just principle, just I am placing, my lord, this placing term, my lord. Para 28.
So equal, pay for equal work.
Yes, my lord. They are providing equal works, my lord. To the
But
same
you are,
children.
teaching the students of lower primary.
Yes.
And they are teaching the students of upper primary. school.
No, my lord, 1 to 4 and, my lord, 5 to 8. 5 and 6 to 8. Same,
Yes, para 28.
para 28, my lord. 2010 5 SCC 225. Just the state government category stated that the pay review committee's general recommendation that only posts carrying a particular scale of pay should all be given automatically the same higher pay scale could not be accepted, as the committee did not make the recommendation after considering the duties of the responsibility attached to the different categories of posts. Therefore, we are of the view that state government was just enacting in the recommendation of the third pay commission and rejecting the recommendation by the pay review committees. And subsequently, in view of the submission by the state government, we direct the state government to extend the benefit of pay scale so and so, paragraph 32 also.
Yes.
And the last, my lord, judgment, my lord, 2010 7 SCC, my lord.
Yes.
That is at relevant paragraph is, my lord, 16 only, my lord. Pay scale is a legitimate right of an employee, and except for valid and proper reasons, it cannot be varied. That only in accordance with law, none of these justifiable reasons exist in the present case. The impure order itself does not give any reason. The expression erroneously used in the order can hardly justify the withdrawal of such an existing right. After 5 years, 7 years, it was enhanced, my lord. This pay scale, my lord. Subsequently, they have again, my lord, reduced. That is only, my lord.
It was not after a long period, within a year, they have revised it.
No, my lord, 2010, earlier ROP was 2010. This one is 17. A lump sum amount, my lord.
I am also relying upon this particular judgment, my lord. I would like to place just two paras, my lord. That is, my lord, 2010 5 SCC 225. Their contention is this, my lord. In 2010, they were getting the same grade pay. in 2017, how it has been now decreased. Lordship will see, my lord, para 22 of this particular judgment, which I have,
Which judgment you are relying?
2010 5 SCC 2 to 5.
Same.
Just now he has placed, it's in our favor, in fact.
Para,
Para 22, may I read it, my lord, short para. The claim in the writ petition was not based on the ground that subject post and reference category post carried similar and identical duties and responsibilities, but on the contention that as the subject post holders and the holders of reference category post were enjoying equal pay at an earlier point of time, should be continued to be given equal pay even after pay revision. In other words,
which para you are referring?
para 22, my lord.
22, yeah.
Yes.
The claim.
The claim in the writ petition was not based on the ground that subject post and the reference category post carried similar or identical duties and responsibilities, but on the contention that as the subject post holders and the holders of reference category post who were enjoying equal pay at an earlier point of time should be continued to be given equal pay even after pay revision. In other words, the parity claimed was not on the basis of equal pay for equal work, but on the basis of previous equal pay. 23. It is now well settled that parity cannot be claimed merely on the basis that earlier the subject post and the reference category post were carrying the same scale of pay. In fact, one of the functions of the pay commission is to identify the post which deserves a higher scale of pay than what was earlier being enjoyed with reference to their duties and responsibilities, and extend such higher scale to those category of posts. The pay commission has two functions: to revise the existing pay scale by recommending revised pay scales corresponding to the pre-revised pay scales, and secondly, make recommendations for upgradation or downgrading posts resulting in higher pay scale or lower pay scale, depending upon the nature of duties and functions attached to those posts. Therefore, the mere fact that at an earlier point of time, two posts were carrying the same pay scale does not mean that after the implementation of the revision in pay scale, they should necessarily have the same revised pay scale. So this was the view given by the Honorable Supreme Court. One more judgment, my lord. 2007 8 SCC. (279). I've given the book list. 2007 8 SCC 279. Well, para 24, page 290. Page 290, para 24.
Yes.
The principle of equal pay for equal work was propounded by this court in certain decisions in the 1980s. Example, the Dhirendra Somali versus State of UP, so and so. This was done by applying Article 14 and 39D of the Constitution. Thus, in Dhirendra Somali's case, this court granted to the casual and daily rated employees the same pay scale as regular employees. Now 26, fixation of pay scale is a delegate mechanism which requires various consideration, including financial capacity, responsibility, educational qualification, mode of appointment, etc. And it has a cascading effect. Hence, in subsequent decision of this court, the principle of equal pay for equal work has been considerably watered down, and it has hardly ever been applied by this court in recent years. In 27, thus in the state of Haryana versus Tilak Raj, it has been held that principle can only apply if there is complete and wholesale identity between the two groups. Even if the employees in the two groups are doing identical work, they cannot be granted equal pay if there is no complete and wholesale identity. Example, a daily rated employee may be doing the same work as a regular employee, yet he cannot be granted the same pay scale. Similarly, two groups of employees may be doing the same work, yet they may be given different pay scales if the educational qualifications are different. Also, pay scale can be different if the nature of jobs, responsibility, experience, method of recruitment, etc. are different. Here, in the last one, my lord, para 37, similar, others are, my lord, same, my lord, opinion has been given by the Honorable Court. Last, my lord, para 37. Similarly, in the state of Haryana versus Haryana Civil Secretariat Personnel Staff Association, the principle of equal pay for equal work was considered in great detail. In para 9 and 10 of the said judgment, the Supreme Court observed that equation of post and salary is a complex matter which should be left to an expert body. The courts must realize that the job is both a difficult and time-consuming task, which even experts having the assistance of staff with requisite expertise have found it difficult to undertake. A fixation of pay and determination of parity is a complex matter which is for the executives to decide. Granting of pay parity by the court may result in a cascading effect and reaction which can have adverse consequences. By the Union of India versus Pradeep Kumar Dey. And regarding, my lord, this pay commission, my lord, thus I will refer the paragraph, my lord. Lordship may consider that the citation 2. It is 2025 SCC 421. 2025 SCC 421. Para 33, 34, 35, 36, 37, 38. Regarding, my lord, the opinion of the expert body, my lord, which should be considered by the Honorable Court regarding pay scale, my lord. Para 33.
Just a minute.
Para 33. Observing that it is the function of the government which normally acts.
Just.
My lord. Para 33 to 38, ma'am. Regarding the expert body's view.
Yes. Para,
33, ma'am. Page 440.
yes.
Observing that it is the function of the government which normally acts on the recommendation of the pay commission, which is the proper authority to decide upon the issue. In Union of India versus PV Hariharan, it was held as under. It is a function of the government which normally acts
Yeah,
on the
that's right.
recommendation.
Yeah,
My
yes.
same, my lord, issue. From 33 to 38, my lord. Same has been given, my lord. Reiterated, my lord, by the apex court. And one last judgment, my lord, on the point of negative equality, which the petitioner is claiming. 2013-14 SCC, page 81. On the point of negative equality.
2000.
My lord, 2013-14 SCC, page 81. Para 8. Paragraph 8, ma'am.
No concept of negative. Yes.
It is a settled legal position that Article 14 of the
27.
para, my lord, yes, but para 8, my lord. 8. It is a settled legal position that Article 14 of the Constitution is not meant to perpetuate illegality or fraud, even by extending the wrong decisions made in other cases. The said provision does not envisage negative equality, but has only a positive aspect. Thus, if some other similarly situated persons have been granted some relief, benefit inadvertently or by mistake, such an order does not confer any legal right on others to get the same relief as well. If a wrong is committed in an earlier case, it cannot be perpetuated. Equality is a treaty which cannot be claimed in illegality and therefore cannot be enforced by citizen or court in a negative manner. If an illegality and irregularity has been committed in favor of an individual or a group of individual or a wrong order has been passed by a judicial forum, others cannot invoke the jurisdiction of the higher or superior courts for repeating or multiplying the same irregularity or illegality or for passing a similarly wrong order. A wrong order decision in favor of a particular party does not entitle any other party to claim benefit on the basis of the wrong decision. Even otherwise, Article 14 cannot be stretched too far, for otherwise it would make functioning of administration impossible.
Give you this photo state copies
Yes, sir. I will provide.
and it's, I think the paras which you have.
Mine.
You have already submitted the.
Yes, my lord. If anything is there on the next, if anything is there, my lord, I also will say
Again,
one, two more judgment press, my lord, my learned friend has already.
so judgment, if he has shown 5 judgments, you are also supposed to show 5 judgments.
My lord, I am for item number 4, Lord. I may be allowed to.
Same, eh?
No, topic is there. I may be allowed
The
to.
difference between,
Similar, but some issues are there, Lord.
yeah,
Lordship, what happened in this case, Lordship?
page,
Lordship, item number 4.
yeah.
Lordship, the past the 2010 Lordship introduced the category of teachers, both in ME and LP school, and their nomenclature was categorized, Lordship. And the 2010 Lordship, page 23 of my petition, Lordship,
Page,
23. This is the relevant page of Lordship, Assam Services ROP Rules 2010, Lordship. Lordship, Assam Lower School Serving Teaching and Inspection ME, MB Senior Basic Schools. Here the categories are Headmaster, ME, MB Senior Basic Schools. This is the pay scale. Graduate Teacher Science, separate category. Trained and Graduate Teacher. Payment to Lordship, grade pay is 2,300. In the below, Lordship, LP Junior Basic Pre-Primary Schools, trained graduate teacher. Payment to same pay.
graduate teacher, where is that?
Yes, trained
Page
graduate teacher.
23 or
23, Lordship. LP Junior Basic Pre-Primary Schools in this category.
Headmaster, graduate teacher, undergraduate teacher and craft teacher.
Lordship, these categories are for ME, MB Senior Basic Schools. And among them, Lordship, the trained graduate teacher, the trained and graduate teacher, this payment to the scale is 5,200 to 20,020. Grade pay is 2,300. The below, Lordship, the category of LP, Junior Basic and Primary Schools, the first is trained graduate teacher. The first is the LP school first category is trained graduate teacher. The payment is same as ME schools trained graduate teacher. And grade pay is also 2,300. Same, Lordship. Subsequently, Lordship, by a
The ROP 2010.
Lordship. And this ROP 2010 is the first Lordship rule which introduces this categories, Lordship.
Yeah.
Earlier, there was no such category. And Lordship, thereafter, this grade pay was enhanced both for ME and LP.
Yeah.
And it was enhanced to 2,700. 2017, the petitioners were appointed by a common order. And Lordship, their appointment is first Lordship, they were, when they were appointed, they were allowed, Lordship, the grade pay of rupees 2,500 And subsequently, when it was come to the notice of the authorities that they all are trained in graduate teachers, then they were allowed 2,700 as per ROP rule 2007, 10.
The fact,
Yes,
that is the fact.
yes, Lordship. Thereafter, Lordship, this 2,700 was enhanced by 2017 ROP rules,
Up to 8,000.
8,700. After that, Lordship, when all the teachers are their pay scale was, Lordship, they are started to get their salaries and they received the salaries till September 2017. Subsequently, Lordship, the finance department started to issue WT message one after another, Lordship.
Committee and.
Oh, Lordship, they are started the WT messages one after another. And then against the WT messages, administrative WT message, the petitioners and some other persons approached before this honorable court. The honorable court set aside all the WT messages. I have annexed the judgment, Lordship. And in the meantime, the petition authorities constituted the anomaly committee. Lordship, kindly there was the anomaly committee, Lordship. Order of anomaly. What is the power of the anomaly committee?
The anomaly committee is no power. In fact, it has only
Page,
recommended
page 71. Kindly for a moment, Lord.
page 71.
One. The notification by which the anomaly committee was constituted.
Yes.
Lordship, the governor of Assam is pleased to constitute with immediate effect a committee constituted with the following to examine the anomalies, if any, in the recommendation of the 7th Assam Pay and Productivity Pay Commission and government decisions taken thereon. This is the members and their power, Lordship, is the committee will devise its own procedure. All the departments officials under the state government will furnish the information and documents, also other assistance as may be required by the committee. The government expects that service association and other concerned will extend their fullest cooperation and assistance to the committee. The committee will submit its report. The committee is to examine, Lordship, if any anomalies in the 7th Pay Commission, Lordship. 7th Commission, which is the result of 2017 ROP rules. But the anomaly committee submitted its reports, Lordship. I have annexed page 72. Lordship also perused earlier about it. And in this, Lordship, page 73, Education Department, the married law, in the middle, page 73.
73. Okay, this is 75 is the original.
Yes, sir. 72 is the starting, Lordship, and 73 is the relevant. What the anomaly committee recommended.
Yeah.
Yes. Then from the middle, but the fact is that in case of LP junior basic schools, there are no signs. Lordship, I may be allowed to enter anomaly in grade pays of graduate teachers. The finance PRU department has referred the matter relating to the pay fixation of teachers of lower primary and upper primary schools to anomaly committee. In this connection, the committee examined the recommendation of 7th Pay and Productivity Pay Committee contained in finance transfer. The commission feels that at the level of LP and ME schools, there are no justification for differentiating the qualification of science graduate, vice versa arts graduate, or any other graduate. Accordingly, the commission recommends that the entire graduate teacher in LP and ME schools should have the same grade pay of rupees 3,300. It is further recommended that all other teachers who have undergraduate teachers should be put in grade pay of rupees 2,500. In the above recommendation, the 7th Pay and Productivity Committee mentioned that there is no justification for differentiating the qualification of science graduate, vice versa, arts graduate, or any other graduate teacher in case of LP and ME schools. So the commission recommended pay scale to other trained graduate teachers at par with the science graduate teacher without discrimination. But in fact, is that in case of LP junior basic schools, there are no science, arts, or any other graduate teachers. The category of post exists only in ME schools. the committee examined the minimum entry qualification required for the various categories of post of teachers as per existing applicable service rule. The minimum qualification of the teachers of LP school is undergraduate. Therefore, this scale of pay of graduate teachers prescribed is not justified in case of teachers of LP school. Lordship, they are considered the entry qualification of LP schools, the assistant teacher. But they have recommended the same teachers, Lordship, who are
Recommended
the same teachers who are serving in ME schools, and they are also entry qualification also intermediate, Lordship. But they are allowed 8,700. And the recommend the my responsible submission is that the anomaly committee, first of all, Lordship, they have different tried to correct the anomaly in the 2010, Lordship, because in 2010 ROP, both the LP school trained graduate teachers of LP school and ME schools are given same grade pay. Both in 2010 ROP, both have given the equal pay scale. And the 2010 ROP treated both categories of ME school and LP schools are similar, Lordship. But the 2000 the anomaly committee what have done, Lordship, they have differentiated them the categories, Lordship, and recommended the grade pay for LP school, a trained graduate teacher of LP school of for 7,400 and for ME school 8,700. So on the basis of this recommendation, the notification was, Lordship, issued, Lordship, which was impugned in this, Lordship, the petition. And by this notification, what my learned friend is submitting earlier, Lordship, that they are not allowing the grade pay of 8,700 of LP school teachers who are assistant teachers, who are and whose entry qualification is also, Lordship, intermediate. They are not getting, but some, my friend has submitted.
that is there.
They are saying that this is a mistake. In fact, this is not mistake, but it is they are allowing them as on the basis of their notification. On the basis of their notification, Lordship, and they are discriminated with the petitioner, Lordship. Lordship, and the Lordship, the basic point is that, Lordship, they are treated as the entry qualification of petitioners and the ME school assistant teachers. May I submit, Lordship, the entry qualification? I have category stated in my petition in page 14, para 8, page 14, para 8. May I read, Lord?
Yes.
That the petitioners most respectfully further beg to state that the anomaly committee adopted an imaginary method violating the existing applicable service law while recommending the grade pay for trained graduate teachers of LP school and ME school and other primary upper primary schools. It is stated in the report that the minimum entry qualification of the teachers of LP school is undergraduate. Therefore, the scale of pay of graduate teachers prescribed is not justified in case of teachers of LP school. So the committee recommends the grade pay of rupees 7,400 for trained graduate teachers of LP school. But on the other hand, while recommended the grade pay of rupees 8,700 for trained graduate teacher of ME school and other upper primary schools, the anomaly committee, without any justification, totally ignored the entry qualification of the said teachers, violating the existing service rule. As per the existing service rule, the qualification of assistant teacher of both lower primary and upper primary is similar. It is clear from clause 3 of clause 3A to rule 3 of Assam Elementary Education Commission of Rules 1973. Lordship, this is the rule. Here, Lordship, the assistant teacher was the qualification of assistant teacher is clearly mentioned, Lordship. This is the book. The qualification assistant teacher, minimum qualification of higher secondary or any other examination of equivalent standard having 45% marks in any of one of the qualifying examination higher secondary or HSLC for general categories and minimum 40% marks for reserved category shall be the minimum qualification for the post of assistant teacher in lower primary and upper primary schools. Subsequently, on 23rd August 2010, the National Council for Teacher Education, NCT, prescribes the minimum qualification of teachers in class 1 to class 8 in elementary school. By this notification, the qualifications of teacher of class 1 to 5 prescribed senior secondary or a secondary with different percentage of marks along with different professional degrees diplomas, and for class 6 to class 8 prescribes a senior secondary or graduate with different percentage of marks along with different professional degree, and also prescribed teachers eligibility test for all. This said notification exempted the teachers who were appointed before 23rd September 2010 in accordance with the prevalent requirement rules from its effect. Therefore, by notification dated 29/7/2011, the NCT amended its earlier notification of 2010 and notified the similar qualification for class 1 to class 8, that is graduation or senior secondary, along with other conditions. Later on 28/6/2008, the NCT again amended the notification of 2010 and inserted or graduation with at least 50% marks and Bachelor of Education BEd as qualification of teacher of class 1 to class 5, which part was omitted earlier in comparison with the qualification of teacher of class 6 to class 8. Thus, the qualification of assistant teacher of class 1 to class 8, that is elementary level, is similar as on today. The entry qualification of assistant teachers of both lower primary and upper primary schools prior to notification of 2010 was undergraduate, and subsequently it was made graduation. In fact, the petitioners were appointed in the year 2016. At that point of time, the qualification of assistant teacher for LP school were graduation, along with professional qualifications, that is 2 years diploma in elementary education, and the candidate must qualify the TET examination. The same qualification were also prescribed for assistant teacher of ME school. Thus, the entire qualification of the petitioners was graduation similar to the qualification of the assistant teacher of ME school. Therefore, reducing the KP from 8,700 to 7,400 of trained graduate teachers of lower primary schools on the point of entry qualification, and other ground, on the other hand, allowing the APO of rupees 8,700 to trained graduate teachers of upper primary schools, ignoring the entry qualification in a discriminatory manner as recommended by the anomaly committee, and the decision of the government on the said recommendations by notification issued by the state government of Assam is unfair, illegal, and double to secretary. And may I submit a judgment, only one judgment.
Yeah.
Only one judgment, it was 2017. Legal. State of Punjab. State of Punjab and others versus Senior Professional Staff Masters Association and others. 3 bench judgment, Lordship. Judgment. Page paragraph, Lordship, 18, Lordship. Page 16. Mary, Lord.
Yes.
We are conscious of the fact that a differential scale on the basis of educational qualifications and the nature of duties is permissible. However, it is equally clear to us that if two categories of employees are treated as equal initially by some cogent reasons, in a case where the nature of duties is drastically altered, a differential scale of pay may be justified. Similarly, if a higher education is prescribed for a particular post, a higher scale of pay may be granted. However, if the basic qualifications and the job requirements continue to be identical as they were initially laid down, then the court shall be reluctant to accept the action of the authority in according a differential treatment unless some good reasons are disclosed. Thus, the decisions relied upon by the learned senior counsel are clearly distinguishable and are not applicable. Conclusion 19 law. In view of the foregoing discussion, we are of the considered opinion that the High Court was fully justified in declaring that the vocational masters are entitled to pay scale of pay rupees so and so on the ground that the nature of duties being discharged by the vocational masters are the same as vocational lecturers, and that there was no rationale behind making a classification between the two equally, especially when both the categories were treated as one and the same is all the previous pay revisions since 1978 onwards by notification dated so and so. Only the nomenclature of vocational masters was changed without changing their nature of duties and pay scale. Further, the impugned order dated so and so describes to be quashed on the ground that it has been passed without complying the rules of the natural justice. The same could have been passed without keeping an apology of hearing to the concerned employees. And paragraph 17, my lord. Paragraph 17, the most important lord.
Paragraph
Paragraph 17.
17,
1 second.
17.
Yes.
First you have read this, paragraph number 18 and 19 and now
Yes, this
17.
is- The principle of equality is also fundamental information of any policy by the state, and the clarity of the same can be found in Articles 38, 39, 39A, 43 and 46, embodied in Part 4 of the Constitution of India. These articles of the Constitution of India mandate that the state is under a constitutional obligation to ensure a social order, providing social justice, economic and political by inter alia, minimizing monetary inequalities, and by securing the right to adequate means of livelihood, and by providing for adequate wages so as to ensure an appropriate standard of life, and by promoting economic interest of the weaker section, meaning thereby if the state is giving some economic benefits to one class while denying the same to other, then the onus of justifying the same lies on the state, especially in the circumstances when both the classes or groups persons were treated as similar in the past by the state. Since vocational masters have been drawing the same salary as vocational lecturers were drawing before the application of Fourth Pay Commission, any attempt to curtail their salary and allowances would amount to arbitrariness, which cannot be sustained in the eyes of law if no justification, reasonable justification offered for the same.
Yes.
Lordship, in here, our case, Lordship, the 2010 Lordship, the rule which first introduced the this nomenclature,
Equivalence.
Lordship, and in 2010 Lordship, from the 2010 Lordship, for LP school, trained graduate teachers of LP school and trained graduate teachers of ME schools, both are treated as same Lordship, and they are allowed the same pay scale Lordship, and even 2017 also allowed the same grade pay Lordship, but by way of the anomaly committee and on the basis of this, their recommendation, the notification was issued Lordship, amending the rules of 2017 Lordship, which is Lordship discriminatory, and the Lordship that may be passed Lordship.
Because what is the?
Fine.
Item number 9.
May it please Lordships. Lordships, by way of the instant PIL, what was asked for was a small compensation for those inmates who are incarcerated in the jails of Assam. Initially, the prayer was made in respect of only one gentleman, Thereafter, by way of various judicial orders, the scope and ambit of the PIL was widened. And this honorable court was pleased to take the entire state of Assam status.
Mr.
My lord, the latest status is that, my lord,
2023 order.
Yes,
Lord,
Your Lordships.
the latest development is this, my lord, after preparing the cabinet memorandum, some amendments have been made. So we pray for some further time
Amendment in what?
in the cabinet memorandum. Lord, we will see, my lord. Subsequently, the proposal came from the Inspector General of Police. And some amendment has been made to the cabinet memorandum. Now we will be placing it before the judicial department for their views, and thereafter it will be placed before the cabinet.
How much time?
Lord, we will proceed after 4 weeks, my lord. Pursuant to the court's order, the government is doing
Pending
their job.
since 2020.
Lordships. And in fact, the order was passed in November 2023, Your Lordships.
Yes.
It's almost 8 months since.
The latest instruction I got it, my lord, yesterday, my lord. So Lordship will kindly grant us some time because it will be placed before the cabinet, it will be implemented.
Specific direction to you.
My lord, I understand that.
What are those, and ultimately the original this cabinet proposal was what?
They have not placed it before Your Lordships.
No, it was amended, my lord. Before placing,
Amended? What was the unamended? Where was that unamended?
my lord, that I can, my lord, in the
Nothing
way
is
of an
before.
affidavit, I can place it. But my lord, Lordship will see the last page of my ban.
Yeah.
Draft policy for payment of compensation. This was probably, my lord, some changes were made there. For the benefit of the, my lord, persons concerned, my lord, they will get probably more compensation.
They don't know whether more or less
I understand, my lord.
is not.
Lordships, if they could perhaps place it by way of an affidavit, we
That, my
might
lord, Lordship will
perhaps
post it for,
get
after
some
4 weeks. In the
opportunity of
meantime, I will file my
responding to it.
affidavit also, whatever is the latest development.
We don't want your affidavit. We want this policy.
Lordship.
Cabinet decision must be regarding payment of compensation.
Yes, yes,
to all
my
the
lord, yes. Pursuant to
persons.
court's order, they are now working on
They
it.
have to,
Then 2 weeks, my lord, I will file my.
whatever it may be, take a final decision. The state has to take a final
Yes,
decision.
yes, we will have to take.
Now,
So I'm praying
this
to the-
cabinet memorandum
No, my
will be
lordship will
amended
post it.
and then it will be sent to the law department and then again, and then you'll take another year.
Lordship will record it in the order, my submission, and will grant us a reasonable time, my lord, we will act upon it.
Nikhil and concept of the. Mr. B. Goel and concept of any further respondent has submitted that. Actually, the cabinet memorandum was prepared in terms of the order dated 7/11/2023. But as per the recommendation from the Director General of the Police, some amendments are required to be made in the cabinet memorandum. It is submitted that Mr. Gogoi has assured not by the Director General of Police नहीं करना इसमें कर देना Inspector General of Prisons है ना on the बताना एक बार ऑटो बताना it is read now.
What's about the forward for you? What's about the forward for you? वहाँ पर compensation का सब
Passed by this court. See, but on the but the Inspector General of Prison has submitted a modified draft policy and pursuant to that some amendments are to be made in the draft policy. It is further submitted that after the said amendments, the matter will be placed. The matter will be referred to the Judicial Department for vetting, and thereafter will be placed in the cabinet for discussion and approval. Mr. Gogoi has shown this court that the final decision regarding the final decision in the matter would be will be taken by the cabinet within a period of,
4 weeks, my lord.
sure, within a
My
period
lord,
of 4
without
weeks,
instruction, I am saying, but
within a period of 4 weeks from today. In view of the submissions, paragraph, then in view of the submissions made by Mr. Gogoi, there is this petition of 4 weeks on that day.
Lordship.
Mr. Gogoi may place on record the copy of the cabinet decision. Date then after 4 weeks, specific date, Mr.
22nd August.
19th of or
22nd.
27th of August. 27th of August. Just on 20.
Deeply obliged, Lordship.
Item number 10.
Meet please, Your Lordship. My lord, I am appearing for the Investor Grants Commission.
Yeah.
Last occasion, my lord, due to some personal inconvenience, I was absent. I apologize for that. My lord, the basic issue in this petition is that whether the whole institution shall be taken as a unit for the purpose of reservation policy to implement the reservation policy, or in an institution, it will be department wise. Initially, my lord, the view of the Investor Grants Commission was that it should be department wise.
Yeah.
Later on, my lord, as your lordship has come across last occasion, I will not repeat all those, my lord. Now the central government has come up with an act, my lord, that where it is provided that the whole institution shall be taken as a unit for the purpose of implementation of the reservation policy. The logic behind is that, my lord, it may be somewhere in a particular department, there may be only 2 posts. So representation from all the segments of the reservation things will not be there. So it will create inequalities amongst the reservation classes. That is why perhaps at the wisdom of the central government, the parliament has brought this new act, the legislation, wherein it is said that it will be, the whole institution shall be taken as a, all the departments, including.
Where is the latest decision of that UGC?
My lord, after, if lordship can come to the affidavit filed by the government, my lord, it is annexed there in, my lord. Page 37.
Thirty-seven.
Yes, ma'am.
Yes.
If lordship can come to page 38, point number 3, section 3, my lord. Subsection 2, may I read, my lord?
Section 3,
Yes, my lord.
page number 38.
In page 38 of the affidavit filed by the government. Internal page.
Government. 107.
107. The running page is 107. Internal page 38.
107.
Yes.
Yeah,
Lordship got the point number 3, my lord.
yes.
Reservation of posts and recruitments by central educational institutions. Subsection 1, notwithstanding anything in any other law for the timing in post, there shall be reservation of posts in direct recruitment out of the sanctioned strength in teachers cadre in a central educational institution to the extent and in the manner as may be specified by the central government by notification in the official gazette. 2, for the purpose of reservation of post, a central educational institution shall be regarded as one unit. Now, posing here for a moment, my lord, this is it says that this is for the central government only. This act is, but my lord, since the reservation is a concurrent policy, my lord, it's a concurrent subject. So when the central government legislates something, it can override the state legislation, my lord. And the state, my lord, unequivocally has said that they have to follow this particular regulations as far as the central government is concerned. And hereafter also, my lord, if lordship can goes on after that page, my lord, page 39 onwards. These are the notifications and the circulars issued by the University Grants Commission, one after another. informing all the state universities, page 40 also Lordship can see that this ordinance will have to be followed. As this institution shall be regarded as one unit.
Yes. Yes.
That is the only moot issues that whether the institution should be regarded as one unit or that there will be department-wise reservation. Since the law is now my lord settled and the ordinance has been now converted to an act. Therefore, my lord, it is binding on the states, in my respectful submission.
Please, Lordship. Regarding first, that it should be the subject wise or department wise, which will be better. Apex Court has in defense judgment, Lordship. In Vivekananda to TRE, Lordship, page number, Lordship, 19. In case, Lordship, may I read, Lordship? Thus, it could be seen that if the subject-wise equipment is adopted in each cadre or post, in
Which para you are referring to?
page number 19, Lordship, Vivekananda theory case, Lordship.
19. Of
19,
this
19.
division bench judgment.
Vivekananda theory, yes. 19, page number 19, Lordship.
Yes.
Lordship, second paragraph, Lordship. The two judges division bench Supreme Court relied upon Dr. Suresh Chandra. Thus, it could be seen that if the subject-wise equipment is adopted in each service or post, in each cadre, in each faculty, discipline, separately or super specialty, it would not only be clear to the candidates who seek recruitment, but also there would not be an overlapping application of the rule of reservation to the service or post as specified and made applicable to by the section 3 of the Act. On the other hand, if the total posts are advertised without subject-wise specification in every faculty, discipline, specially or super specialty, it will be difficult for the candidates to know as to which of the posts be available either to the general or reserve candidates or whether or not they fulfill or quality the recruitment so as to apply for a particular post or seek selection. That will be similar way, Lordship. In paragraph, in page number 17, similar, same.
Everything
So
is
I am
But ultimately what?
ultimately a department wise, it's
The division bench just said, we therefore,
yes,
last para,
last way. We require by means this judgment, which to remand the request the UGC.
to statute constitution to examine all aspects referred to in the above and submit its recommendation to the Ministry of Remote for its consideration and appropriate decision.
Lordship,
Now the UGC has taken a decision
Lordship.
that the resolution be, the college shall be treated as a unit.
No, Lordship. Thereafter, the decision has been taken, it should be as a subject wise, Lordship.
Where is that?
Lordship.
No, my lord,
That's page number, Lordship, kindly see my petition, say 66, Lordship.
66.
Yes.
Yes.
It is amended. The rule has been amended, Lordship.
Rule has been amended.
Yes.
When?
Guideline has been 2018, Lordship.
January 2018.
Yes.
Rule has been amended.
Yes, Lordship. As per Supreme Court judgment, Lordship.
After this Supreme Court.
Yes, after the Supreme
Where is
Court.
that?
Page number 66.
66. Yes.
This is a UGC guideline, Lordship. UGC letter, Lordship. To the registrars, all central and state universities. Implementations of reservation policy of the Government of India. Sir, Madam, with reference to the subject, I am to inform that for implementation of reservation policy of the central government, so and so, and then directed the UGC to ensure effective implementation of the reservation policy in the central universities and those of institutions deemed to be universities receiving aid from the public fund, except in minority institutions under the article so and so. Article 31 of the Constitution. Accordingly, UGC by letter number so and so, dated so and so, circulated new guidelines for strict implementation of reservation policy of the government. This has been further reiterated in so and so. The Ministry of Human Resource Development, by its letter number dated so and so, has directed the UGC to examine the issues mentioned in the judgment as quoted by the Honorable High Court of Allahabad in its order dated so and so, and submit its recommendation to MSRD for their consideration and appropriate decision. Accordingly, UGC has constituted a committee and submitted a recommendation to the Ministry of Human Resource Development on so and so. Thereafter, the compliance of the judgment of the Allahabad High Court as upheld by the Honorable Supreme Court of India and in view of the advice tendered by the DOPT and recommendation of the UGC, MSSRD, and in so and so, that it has intimated the departments so and so states amended to the extent as mentioned below in the UGC guideline 2006 in accordance with the recommendation of the UGC, which is as under clause 6C. In case of reservation for SC/ST, all the universities deemed to be universities, colleges, and other granting aid institutions and centers shall prepare the roster system, keeping the department subject as a unit for all levels of teachers as applicable. This has been amended, Lordship.
But later on.
Later,
now,
2019,
you are relying on
19
this
central-
2018. Now 2019, if the UGC has again recommended something else, they are not supposed to follow that.
Yes, it is a central education institution for central teachers only.
Yeah.
This ordinance was issued for the central education institution only. I am not central education institution. I am not a state university also. I am a college, Lordship.
Whatever
I am a
it
state
is,
college.
sir, ultimately.
Yes, Lordship, I am going to reply.
So
Yes. Yes, Lordship replies. I'm also bound by the UGC regulation. Lordship, I am happy if the UGC regulation in toto binding in Assam, but the same director of higher education, but same state government, they are saying that no, UGC guidelines are not binding in Assam. This is the judgment, Lordship. Therefore, I am pressing. If Lordship
Whatever
appeal.
the judgment of
Yes, Lordship. Because the guns are from Assam government. This is the plea.
judgment or the decision of the Assam government.
Assam government judgment, Lordship, this court judgment,
This-
yes.
How can it be Assam government judgment? This is a Guwahati High Court judgment.
Lordship, Guwahati High Court judgment, Lordship. Yes, paragraph number, Lordship. Lordship, kindly see paragraph number 27.
27,
From 26, Lordship, 26, Lordship.
yes.
In this aspect, we take note of the contents on Mr. K. Gogoi, Learned Counsel for the Higher Education Department, where reference has been made the proposition of law laid down by the Supreme Court in Kalyani Mathavan, wherein in paragraph number so. Thereof, it was held that UGC regulations are 2010 are mandatory for teachers and other academic staff in all central universities and colleges thereunder, and the institution deemed to be universities whose maintenance expenditure is made by the UGC. In paragraph number so, it has been provided that the UGC regulation of so are directory for the universities, colleges, and other higher education institutions under the purview of the state legislation. As the matter has been left to the state government to adopt and implement to the scheme. Thus, the UGC regulation 2000 are partly mandatory and is partly directory. In paragraph number 62.5, therefore, the Supreme Court has provided that UGC regulation of 2010 having not been adopted by the state of Tamil Nadu, the question of conflict between state legislation and the statutory frame under central legislation does not arise. And in such case, there shall be no conflict between the state legislation and the central legislation. In this instance case, Lordship, this is important. It is stated by the Higher Education Department of the Government of Assam that for the colleges under the department, the maintenance expenditure is not made by the UGC, but it is made by the state government from its own funds, except maybe for certain occasional grants that may be provided by the UGC for further development of the colleges. In spite of such grants being received, the core maintenance of the colleges are from the funds of the state government itself. Accordingly, by referring to the provisions of paragraph so, the provision of the Supreme Court, it is the stand of the government of Assam in the Higher Education Department that the provision of the UGC regulation of 2010 in its entirely are not mandatorily applicable for the purpose of colleges under the government of Assam in the Higher Education Department. And on the other hand, such provisions are directory for the authorities. It is the stand of the Mr. K. Gogoi, Learned Standing Council Higher Education Department, that in exercise of its discretionary power, the provision of so of the UGC regulation 2000.
Sir, what do you want to convey?
Lordship, in some cases,
That was their stand
yes,
before the land, in one of the case,
Lordship.
the court has negated that.
No, court is not negated this. Not. Other than the aforesaid provision has not been adopted, by accepting the statement that the government of Assam is meeting the maintenance expenditure of the colleges from its own fund, except for the occasional grants for development purposes that may be provided, we are inclined to accept the contention of the Higher Education Department of the.
So now,
It has been challenged before, Lordship. The writ appeal is pending. Our case is that you follow UGC guidelines. So, on the top.
so what now they are saying, yes, we will follow the UGC.
Yes, if Lordship going to hold that UGC regulations are binding in Assam government, I have, Lordship, I am.
So that is their stand.
Yes, Lordship, that is that is the stand of
That is
UGC.
their stand that we are bound by the UGC guidelines and therefore we are treating the college as a unit for the purpose of.
Yes, sir. But Lordship, that stand has not been not by affidavit. But another case, Lordship, it has been by another way.
Whatever it may be.
Lordship.
Here there is a
Even if
specific
you are
stand by-
taking a cue from your lordship, the education as a whole, the constitutional position,
Yes,
to,
Lordship.
up to my understanding, my lord, education as a whole is a subject of the state. But maintenance of standard in higher education is a union subject.
Yes, Lordship.
Entry 66, list one. List one, entry 66 is a, that is why, my lord, this
You
is,
are saying that we are treating college as a unit for the purpose of grant of this reservation on the post of this, for the recruitment of assistant professor or whatever the post.
For
As
all
per the
teaching
UGC
positions.
As per the UGC regulation.
Yes.
yes,
State is also saying the same thing.
same thing.
Same
my lord.
thing.
And he also wants the same thing. He also wants the same thing.
But Lordship,
What remains?
but Lordship is that they are taking different stand in different cases. Lordship, UGC.
But that is for the court to deal.
So
That is
Lordship,
for the
my
court to deal whenever
my
the
point
matter
is that-
comes. Here now in this matter,
Lordship.
your essential prayer is that the reservation should be provided department wise or section wise.
Right.
They have come with this, that we can't grant that because the UGC says something else and therefore we are granting reservation while treating a college as a unit.
Unit, Lordship.
That's all.
That's all.
all.
This is the only thing.
That motivation, that ordinance have to be adopted by the state government. Till date, not adopted, so
Not
adopted.
adopted or whatever it may be, now they are in tandem with the UGC,
Yes, yes.
whatever the guidelines and
That's-
what remains.
So the action is to follow the UGC guideline, Lordship, that the central government's elections.
Okay.
Earlier, I thought
That
that
is all.
central government institution, central government ordinance, that was challenged before the Supreme Court. Supreme Court says, no, it is a matter of High Court. You can challenge also High Court. So that is remanded back, Lordship.
Fine.
That is the matter, Lordship. Plus.
Item 11, 11 and 12.
Unless the senior counsel Mr. D Das, he's on late in court number 7. If it is not inconvenient to your lordship, can he be taken up at 2,
When?
at 2 o'clock or any other day?
For lunch.
Item 13,
So here also, your lordship.
But in this case, I need some accommodation, my lord. Learned AG is arguing this matter, my lord. He is in Lakes in court number 5, my lord, in a special division bench, my lord, and that will continue, my lord. Any other date, my lord?
Your Lordship, at 2 o'clock, if your Lordship,
No, that will, my lord,
Busy
Hello.
after a week, next week. Item number 13.
Yes, Lordship, there is some urgency in the matter.
Now it's saying, AG is busy in some other.
Yes, that's
special
correct,
night.
Lord, that's correct. So Lordship, sometime in the next week, maybe.
That's why.
Oh, yes, yes, we are obliged, Lordship. Yes, Lord. Next week.
Item 14,
May please, your lordship. I pray for filing an affidavit. What happened during the pendency of the suit? In spite of the interim order dated 25/08/2020 and during the pendency of the case, APSC respondent number 4 conducted the interview
On
and
that day,
conducted the interview and selected one person.
okay, you want
Junior
to file
person.
an affidavit?
Yes.
2
Eh,
weeks.
no, no, I am going to file an affidavit, but I pray for 2 weeks time.
2 weeks,
2 weeks time.
urgent.
Yeah. After 2 weeks,
2 weeks urgent, sir. As per your request, we have adjourned the matter for 2 weeks.
not filing the affidavit.
There is no need to mention that. You find an affidavit, we'll take it there on the court.
I'm for the Tinsukia Municipal Board, man. We are aggrieved by an order passed by the learned single judge. Now, while it was deliberated before this honorable court, the honorable chief, then Chief Justice said, why don't you just try and discuss with other municipal board? Because it's a case where, my lord, whether they are entitled to get the employee the 6-pay commission or not. That's the whole issue. The learned single judge says that no, they are entitled to get 6-pay commission. But with great respect, I would rather say that there was an affidavit filed by us. 2, 3, 4 letters were overlooked. I somehow
Overlooked by the
learned single judge because the executive committee, because the decision has been taken by the board first, and board has taken a resolution that yes, you are entitled to get a more salary, higher salary you are entitled to get, but not on the 6-pay commission. There's a resolution by the board, and there is a provision under the act. That act is 37 of the act. Now, the chairman of his own takes a decision and says that no, they are entitled to get a 6-pay commission. Now, on the basis of that, they come up before the learned single judge, and they try to enforce that letter, that there is a letter issued by chairman and they are entitled to get a 6-pay commission. An affidavit was filed before the learned single judge said that no, there is a letter which has been written by the executive chairman, executive officer, stating that no, there are a lot of financial problems are there. Government has said that please, no appointment should be made. There are a lot of financial problems are there. And this letter was addressed to the chairman. Chairman has seen that letter and chairman said, oh, no, I have passed an order. I am keeping that order in abeyance. These 3 letters were not looked by the learned single.
Which letter we kept in abeyance?
The letter which was addressed by the getting benefit, whether they are entitled to get benefit.
Learned single judge has granted relief to them only on the basis of that letter.
That letter.
Otherwise, no adjudication on law.
No. On that, no. So there no adjudication on law under 37. So when we filed an appeal, we took a leave from the court. This is a legal issue. Court has allowed us. Leave is allowed because that point was not taken before the learned single judge, whether 37 of the Municipal Act. So a resolution taken by the board, whether that resolution, they can, the chairman, without going to resolution, he can take a decision of his own. So we said there is a violation of that resolution. Now, my lord, what has happened? The court said, why don't you take an instruction from other municipal bodies that whether they get the similar benefit of 6-pay commission or not, those contractual employees. That we have written to the other municipal board, and ultimately we found that they are not getting the benefit of the contractual employee doesn't get the benefit. Now there was a meeting. Then the division bench said that why not arrange a meeting with the finance, with the urban development regarding about any solution can be from their side also. Finance has now clearly come that we are not going to help. There is no question. It's all the contractual employees.
All these are contractual employees. But
Not substantive worker.
no, these, my lord, the main employees, the regular employee, they are getting it. But contractual employees, they are not getting it. These are contractual employees. By regulation, we decided to enhance they increase the wages. We have decided to increase it. But they are saying that no, even we are contractual, we are entitled to get under the 6 pay commission. Whether
If they are discharging the similar duties.
that's what
as a-
I
As the regular employees are.
no, that's what I also, my lord, that's what I told, that this is also same view, that equal work, equal pay. Whether that's the concept of equal work, equal pay. Now the question whether they are discharging, but only the difficulty is that we cannot give the salary to them, the 6 pay commission. Only the government can grant the 6 pay commission. This is a government exchequer. How can we, my lord, we are only a board. What we can do it, we collect taxes, whatever, then pay to them the wages. But the regular employee, there's some consolidated amount we get it from the government. According to that, we make their payment. Now, there are few letters I can indicate where the government has said, please don't go ahead because there is a financial problem. And there is an order passed by the chairman itself, keeping itself his own order in abeyance. Now, if the government says that no, there is no difficulty from our side, we can pay. For us, there is absolutely no problem now. Now, government has to give a
Has
reply.
already refused.
Yes, I don't know what's the government, what is the stand? Now the government, I think they have got some instruction.
Because some instruction, it has been paid. Only extra copy. I think there's the whole thing. There's a big more problem. I'm sorry.
Yes, yes. Where is the government of the system? It goes against all. Right. Government are not really good. No, these commission are not doing that. One of the only difficulty, so where is that letter? Letter.
Letter. What is this letter? This letter says these rules shall not apply to the employees of government registered societies and missions, etc. As such, the employees of the municipal board are not entitled to get the benefit of pay commission. Municipal board is not the government registered society. But they constitute under this municipal tax.
Because they are not a regular employee under the pay commission. These contractual employees are not under the regular. Benefit to be given to the government pay commission. My lord, if your lordship, for a moment.
It can happen also, can I go to this through an affidavit stating that why they are not entitled for the 6 pay commission?
You
Means urban Department of Housing and Urban.
You have filed affidavit.
No, my lord. In
You
with
have to
regard
file
to
an
this, my
affidavit.
lord. Why they are not entitled?
Have you filed any affidavit before the land?
No, they have not filed.
Single paper file for that. Like.
If your lordships kindly see the appeal which you have filed, page 47 kindly be looked into it.
Just a minute.
Yes, yes, of course.
Last,
Yes,
no mention about this, whether these are the contractual employees or regular employees.
Your
Nothing is
lordship will
there on the
find-
discussion.
see page 47. That's why I was trying to show page 47. See page 47. That the resolution of the of minutes of meeting. If I read this, my lord.
Yeah.
In today's meeting, there has been discussing over the application for increase of monthly salaries of the Harijans, the laborers and employees of the office. They were earlier drawing their monthly salary as per pre-revised scale. When all the members wanted to know as to how much more would have to be paid if the monthly salary were to be increased, it was conveyed that if it was to be given as per Labor Act, then rupees 59,000 more would have to be paid. And if were to be given as per pre-revised scale, then amount of rupees 5 lakhs more would have to be paid per month. In this context, the former president said that the information is required to be taken as whether a Dibrugarh, Sipsagar, Jorat Municipal Board have been paying increased monthly salary or not. After having discussion, all the employees expressed their proposition that instead of regularizing all employees, increase monthly salary from the fourth grade onwards ought to be paid with effect from the month of March. And it was also decided that such benefits would be subject to certain conditions, and those employees who violated such condition would be deprived of the benefit of increased monthly salary. So that's the board resolution. Now, if your lordship kindly see next at page 51.
Yes,
Chairman, chairperson
yes.
on 23. This is to inform you that those employees who have been drawing monthly salary as per the scale of pay prescribed by the Fifth Pay Commission will now be entitled to scale of pay prescribed by the Sixth Pay Commission with effect from 1/3/2017, applicable from fourth grade basic scale and onwards, as decided by resolution number 10 Shaw in the sixth general meeting held on 17/2/2017. And the scale of pay is hereby ordered to be prepared accordingly. Now, if your lordship sees, and I have read 47, there is nothing that they will get that scale of pay. Sixth Pay Commission, your lordship will kindly see
This is
47.
what the resolution which is reference office which is made in this letter dated 20th of March 2017.
Yes,
This is the resolution of number 10, Chair.
yes, at page 47, which I have read. Kindly see at page 47.
Yeah, that. Yeah.
Sixth general meeting held on 17/2/2017. Now, basis on this, my lord, they moved a writ petition saying that they are entitled to get the benefit of Sixth Pay Commission. Now, in this case, we file an affidavit before this court. Kindly see, my lord, the affidavit which was filed, which starts from page 58. 58.
Yes.
Yes. And page 61, our whole case is they are purely temporary basis. At page 61, kindly see, 61.
Yeah.
See, that the deponent said all the petitioner working as temporary and casual staff worker in the office of respondent number 4. Most of the petitioner enrolled employed in the service of Tinsukia Municipal Board and around 1999 on minimum wages act of fixed pay basis. The petitioner are not entitled to salary as per scale recommended by any pay commission. Now,
This is the affidavit
by the board, by us,
by
by
the
municipal board.
chairman.
Yes.
The chairman has passed that order and the chairman has filed this affidavit.
My lord, now what? No, he realized. How he realized? Kindly see. Page 73, kindly see, my lord. 73. 73.
At that time, some other person was the chairman.
Oh, wait, no, 73. Kindly see the order of the government. Kindly see 73, my lord. That's the executive officer, Tinsukia Municipal Board.
This affidavit, page 58, what you are saying, Deepti Das
Yes,
is the chairperson
yes,
of the things
at the relevant time.
at the relevant time.
Yes.
Yes.
Now 73 is a letter of executive officer Tinsukia Municipal Board addressing to the chairperson at page 73.
This is what the letter reference has been made.
That's
This has
what
been
it,
set aside by the learned single there.
now this order, by law 31/3/2017, if your lordship kindly look into it, was set aside. This order is not being set aside, 31/3.
This order is set aside.
31/3.
Yeah.
No, 74, kindly please look into 74. 74, next, at 74. Now, 1/4/2017.
Just, so this letter dated
My lord,
31st of March 2027 has been set aside.
there was no prayer. Now that,
No, it may be
No,
it is
see,
set aside by the learned
please,
single.
74.
Consequently, the letter dated is by set aside, para
No.
number 10,
No, please 74, my lord, 74.
24.
74. This is to implementation order, bearing shall be stayed until further orders. So that's the earlier order has been stayed. The order, which an order has been passed by the chairperson, saying that you are entitled to get 6 pay commission. On the basis of that, they have come. And that letter has been stayed by the chairperson. And this 1/4/2017 has not been put to challenge by them. Page 74.
Yes.
Now kindly see the prayer. Kindly see the prayer at page 42.
Yeah.
At page 43. Shall not be issued calling up the respondent of 428 to implement the order dated 23/2017. Issued by respondent number 5 pursuant to the resolution number 10 so adopted in the 6th general meeting of Tinsukia Municipal Board held on 17/2/17 in terms of which the petition is supposed to get. Now, this is what, my lord, whether, now forget everything, my lord, whether the chairperson can issue this letter in violation of the provision of section 37. That's the case.
Is that fact?
Yes. Now kindly see the act, municipal, Assam Municipal Act. Hmm. $37 million.
Yes.
The power of the chairman. The chairman shall, you also got it, for the transaction of the business connected with the act or for the purpose of making any order authorized thereby exercise all the power vested by this act in the board. Provided chairman shall not exercise any power which shall be exercised under the rules by the executive officer, where such officer is appointed under section 53 of the act. Provided also the chairman shall not act in opposition to or in contravention of any order of the board at a meeting or exercise any power which is directed to be exercised by the board at a meeting. So there was a board meeting which never talked about the pay commission. Now chairman went ahead in contravention with the board's decision and they said that you are entitled to pay commission. So whether he could have acted beyond section 37, that's the issue. My humble submission before your lordship is number 1, that 37 is the power which has been given, but you cannot go beyond the power of 37. You cannot exercise unilaterally that power. Number 2, my lord, there is an order by the executive officer to the chairperson, and immediately thereafter 74, the chairperson has kept that order in abeyance. That was also not put to challenge. So in that view of the number 3, that absolutely no problem. If the government is willing to pay the 6-pay commission, we have no problem. Government has to do it.
Yes.
That's our my submission.
May it please your lord. My lord, first of all, if I may trouble your lordship with the order receipt, the order of the honorable single judge. Now, here your lordship will kindly take a page. It starts from page 121. I beg to draw your lordship's kind attention to page 129,
Para.
para 9.
Para.
May I read this paragraph, my lord?
Para 9.
Para 9, may I read, my lord? As has been submitted by Mr. So-and-so, learned counsel for the respondents number 4, 5, 7, and 8. The respondents were to take the opinion of the Department of Finance, Economic Affairs, and the Director Municipal Administration with regard to payment of salary increment in the revised pay scale. However, no communication has till date been sent by the respondent number 5 to the Department of Finance, Economic Affairs, and the Director Municipal Administration. That is even after more than 5 years from the date of issuance of the impugned letter dated 31/3/2017 by the Executive Officer, Tinsukia Municipal Board. As such, the reason for keeping in abeyance the decision of the Tinsukia Municipal Board to enhance the pay scale of their employees in line with the 6th Pay Commission on the basis of a letter dated 31/3/2017, which has not been acted upon till date, in the opinion of this court, is not only arbitrary and unfair, but appears to be a means to delay the rights of the petitioners to enjoy the benefits which they were entitled to in terms of the order dated 23/2017 issued by the respondent number 5. It is also not disputed by the respondents that employees in all municipal boards in the state of Assam, numbering over 50, are enjoying the pay scale prescribed under the 6th Pay Commission. As such, there can be no justification for denying payment of pay scale in terms of the 6th Pay Commission to the petitioners who are employees of the Tinsukia Municipal Board. Now, my lord, will come to page 132, paragraph 14. As this court has already directed the respondents, especially respondents number 4, 5, 7, and 8 to pay the scale of pay prescribed under the 6th Pay Commission to the writ petitioners number 1 to 9, 16 to 18, 24, and 26. The payment of scale of pay prescribed under the 6th Pay Commission, along with arrears, should be made within a period of 5 months from the date of receipt of a certified copy of the order. Now, here, my lord, we approached this honorable court, the honorable single judge, on a very limited premise. There was a board resolution taken to the effect that those employees of the board.
What is that board's resolution?
My lord, board's resolution, your lordship will kindly see at page 47. This is the translated copy of the relevant extract from the minutes of the
Is
6th
it
general.
correct copy?
This is the,
Is it the correct copy?
yes, this.
Now read this.
Now, my lord, here it says, in today's meeting, there has been a discussion over the application for increase of monthly salaries of the Harijans, the laborers, and the employees of the office. They were earlier drawing their monthly salary as per pre-revised scale. When all the members wanted to know as to how much more would have to be paid.
Show us a mention
My lord,
that they are entitled for the new pay scale or the 6th Pay Commission recommendations. Where is that in the resolution? Where is
my lord, here, my lord, it is not in a very happily drafted manner.
What do you mean by happily or
My lord,
unhappily?
this doesn't
Is it
mind
the letter has to be read
as it is, absolutely, as absolutely, my lord. Now,
Now,
offshoot of this letter, my lord, is at page 52.
and what is the authority of the chairperson? He may ask that grant them pay scale of IAS,
And the municipality is bound to do that.
No, my lord, here, your
But
lordship
there
will.
must be some procedure for that.
True, my lord, here.
What about the other then, when he himself has stated that order or kept in abeyance that?
That,
What about that?
my lord, to that, my lord, may I just respond to that, my lord?
So
Now,
in this manner, if a chairperson can order to do, tomorrow he'll say that every employee is entitled for a car and provide them a car, then every employee will have the car.
true, my lord, here, the order at page 51, that is in reference to the resolution, but unfortunately in the resolution, there is no mention of fifth pay or sixth pay.
Sixth pay.
Yes,
Then
absolutely. True.
enhanced pay, that's all, enhanced pay.
Yes.
Pay them some, money.
Getting
more money.
pre-revised pay scale, they will be entitled to a revised pay scale. This is the only.
Revised pay scale, bhi word kahin hai, to you just show us.
No, my lord, here
Is
basically.
there any word revised pay scale be, is there any word?
My lord,
Not a single word.
my lord, third line, if your lordship kindly sees, page 47.
Yeah.
My lord, they were earlier drawing their monthly salary as per pre-revised scale. That was.
Sir, that's all. Now they are entitled for new, as per new scale. Where is that?
My lord, here the 5 lakhs that they have mentioned, that how much more would have to be given here, it is said that it was conveyed that if it was to be given as per the Labor Act, then rupees 59,000 more would have to be paid. And if it were to be given as per pre-revised scale, then an amount of rupees 5 lakhs more would have to be paid per month. This is the only thing, my lord. There cannot be any development to the case that was there. So.
Sir, even in fact, it's not a resolution. Where is the word? So now onwards, it is resolved that pay them so and so, so and so. Where is that? Sir?
Yes, to that
They
extent.
have simply, in today's meeting, they're discussing over the so and so, so and so. They were earlier drawing salary in so and so. It was conveyed, labor would be so and so, 5 lakhs. In this context, the former president information required to be taken from so and so. After having discussion, all the employees expressed their proposition that instead of regularizing all employees, increase monthly salary from 4th grade onwards ought to be paid from month of March. And it was also decided that such benefit should be subject to certain conditions, and those employees who violate such conditions, where are those conditions? Where are those conditions? Which are those conditions which is referenced in this order dated 20th of March 2017? Which are those conditions? Now that such employees will not, if they are not abide by these conditions, they are not entitled for this. Where is that?
My lord, these conditions were obviously not provided to the employees.
There is no reference to 6 pay commission. Obviously, there is no such reference to any condition.
My lord, regarding the.
A local body runs like this,
My lord,
the whims of a chairman.
My lord.
It's
My lord.
tomorrow you'll accept this, that the chairman will pass an order that as per the resolution of the municipality, their pay is reduced to 4th pay scale. You'll be ready abide by that?
My lord, of course not, my lord, but then.
Not then, sir, how can such sort of, if local bodies are run in this manner?
My lord, here your lordship's query to the effect that whether this resolution was in fact adopted or approved. Now, to that extent, my lord, my reply would be that here, the procedure that generally gets followed by the local bodies, by the municipal boards, that the resolution that is taken in one meeting, that gets approved in the subsequent meeting. Now, your lordship will kindly take page number 111 for a while, my lord. Page number 111.
Yeah.
Now, this is the relevant extract from the 7th general meeting of the Tinsukia Municipal Board held on 7/9/2017.
Yeah.
Now, your lordship will kindly see the very first resolution in that meeting was that minutes of the 6th board meeting held on 7/2/2017 has been read out and the same is hereby approved. Now, here, my humble contention.
Okay. Leave that.
Yes.
Yes, that is approved. There is the mention of 6 pay commission.
That is not there.
That is not there.
That is not there in the
What about-
resolution.
What about the order of this chairperson, whereby the earlier order dated 20th of March 2017 was kept in abeyance?
Now,
Till further orders.
yes. Now, here, my lord, in so far as those two letters that my senior colleague has referred to, one dated 31/3/2017 and the offshoot
That reference is already there in the learned.
is in there. And if that has been satisfied, now obviously the order dated 1/4/2017, that is at page 74. That is an offshoot of that order because this is
Where
where
is the offshoot of that? Letters to what?
if your lordship kindly takes up these two letters for a while once again,
Yeah,
page number 73
yeah.
is the letter by the executive officer addressed to the chairperson,
Fine.
Tinsukia Municipal Board, that is dated 31/3/2017.
Yeah.
And here the request that has been made is the advice that has been given is, hence you are hereby advised to keep the matter of salary increment in revised scale and promotion to any staff in advance till the opinion from aforesaid departments and guidelines from the Office of Director, Municipal Administration and Department of
So
Finance.
this letter goes there, for this letter also goes.
My lord, now here there is another aspect, my lord.
Okay, here,
My lord.
this letter dated 1/4/2017. Where is the mention of this letter of the executive officer that I am this abeyance, keeping this letter in abeyance of the letter dated 20th of March in abeyance as per the advice given by the executive officer?
That is,
Where is that?
that is not there. my lord. That is not there. my lord. And in fact, so far this particular letter dated 1/4/2017 is concerned. About this, we were only made aware after the filing of the affidavit in opposition in the writ petition. It is,
Has to be, sir. That is there in their domain.
my lord, be that as it may, my
So
lord.
they have mentioned it, case this order is in kept in abeyance, therefore they can't ask for implementation of the earlier order.
My lord, be that as it may, my lord, in my humble contention, even thereafter adjudicating upon the issue in its entirety, the honorable single judge had
The
taken.
honorable single judge, sorry to say, sir, you are the contractual employees. Not having taken into
No.
consideration at all.
No, my lord, here also I beg to
This
differ.
letter and what authority this chairman has to issue such type of orders, this has not been taken into consideration
My
or
lord.
even not considered. This letter was kept in abeyance, not taken into consideration despite it is on record.
No, regarding, my lord, the
Simply because at his whims, a chairperson says they're entitled for so and so. So implement it.
My lord, we came only on that limited premise, my lord, that a decision, a resolution was a top.
This was very weak, sir.
My lord, here one more aspect that I beg to draw your lordship's kind attention to is the fact that so far this categorization of the employees are concerned. Even to that extent also, the honorable single judge, despite that aspect being argued before the honorable single judge, that nothing has come, nothing has come up. But here, my lord, in abandoned caution, when this writ appeal was filed, we were, after the passing of the judgment by the honorable single judge, we were in anticipation of the compliance,
Implementation of that.
the implementation. But in the meantime, the writ appeal was filed, and in the writ appeal, this point has again been raised that there is a categorization of employees into permanent and temporary, into contractual, into regular. Now, to that extent, my lord, if I may just argue on this point, my lord, if your lordship kindly sees at page 62.
Yeah.
This is a continuation of their affidavit. If your lordship kindly takes up paragraph G.
Yeah.
That the Finance Economic Affairs Department, Government of Assam notified by its letter dated, letter number so and so dated 21/5/2009, that their department started making payment of salaries to the existing regular posts of local bodies for general areas under the award of State Finance Commission since 2008-09, and again directed not to make any fresh recruitment without the prior approval of Finance Department through the Administrative Department. It was stated in the aforesaid letter that the third Assam State Finance Commission has observed that there is no approved staffing pattern in urban local bodies, and as such, the Finance Department will not provide additional fund for the fresh appointees over the existing regular posts till the approved uniform staffing pattern for ULBs. Here in their affidavit, they are saying, the board is saying that as per the Finance Commission, there is no staffing pattern of the employees in ULBs. And at the same time,
staffing pattern doesn't mean that there is no categorization of regular employees and temporary employees.
Well, in that,
Not the, in the relation to staffing.
my lord, because of which, the very next case, my lord, that your lordship, my lord, that is before your lordships. In this case, there is a writ petition also tagged with this writ appeal. That writ petition, in the writ petition, the municipal board is being represented by my learned friend sitting here. Now, here in this writ petition, my lord, we have actually, after getting to know about this categorization, which by way of the statement showing the detailed staffing pattern of the Tinsukia Municipal Board as on so and so date, we have challenged this, my lord.
Which?
This very annexure 9 at starting from page 61.
Annexure 9.
Annexure 9 at page 61. The writ petition.
This statement showing detailed
Yes.
staff. So why you?
My lord, this I have challenged, my lord, because if your lordship kindly sees the discrimination between the permanent and the, according to them, the fixed pay or MR employees, muster rule employees.
So what is the?
My lord, if your lordship kindly sees, I'll just point out two things, my lord. At page 61,
Yeah.
if your lordship kindly takes up, my lord, say for instance, if your lordship takes up, number 5.
Yeah.
Name of the incumbent against column number 3, Keshav Chetia, computer assistant. His date of appointment is 8/1/2003. Your lordship has got that. Keshav Chetia, computer assistant, date of appointment is 8/1/2003.
Yeah.
Now, if your lordship kindly takes up page 63. This contains the names of fixed pay or MR employees according to them. And here the name of the petitioner number 1 in the writ petition and respondent number 1 in the appeal, that appears at serial number 5 down below, Sri Asim Chakrabarti. So his date of appointment gets shown as 9/1/2001. And there is no content, there is no averment that there has been any discontinuation of service.
So you are seeking regularization of?
No, here only thing that I am trying to refer to is, my lord, the categorization that they are showing by way of this particular statement.
Yeah.
This itself is illegal because this cannot be the basis of categorization where an employee appointed prior in point of time.
Don't be this.
My lord, this is a fresh writ petition, my lord. This is a writ petition.
Petition to be decided by the single judge. Why is the?
My lord, because there is an order by, when this matter was listed before the single bench.
Yeah.
There was an order that since this matter is intermittently connected to the writ appeal pending.
Patently connected, sir.
My lord, that is how, my lord, this has,
Connected.
that is how this has got tagged with this writ appeal, my lord. There was an order in this writ petition. If your lordship kindly sees the order, when the very first day when this matter was listed, there was an observation by this honorable court, by the honorable single judge.
We connected with non-PK.
That is why it has been
It will
listed.
decide.
I am not in this
This
case.
will be decided by the.
Single judge.
My lord, I am not in the second case.
Yes.
Whatever it may.
Yes,
It
it
will be
is
decided by
a
this.
separate cause of action. It is a single judge will decide.
This item number, this writ appeal number 373 of 2022, this order is and this be placed before the appropriate.
Deeply obvious.
Right.
Deeply obvious.